You are still on NewsFile. It's on Joy 99.7 FM. It's live on the JoyNews channel on Multi TV, streaming on our YouTube channel. You can also watch it live on myjoyonline.com. So on Monday, the Chief Justice nominee, Justice Enyeba, will be vetted by the Appointments Committee. And of course, they will have help from the Legal Constitutional Affairs Committee also in vetting him. Now, that date had been agreed, but before that, there was a lot of controversy. A lot of accusations were flying around about, people's parochial interests overriding the national one, and the attempt, as was alleged, by the majority side to push this through. And the minority side had argued quite forcefully that enough time should be given so the public can, come forward with memoranda that may sort of enlighten the process and then make sure that when we approve the Chief Justice, we don't have issues there that may come back to haunt us in terms of his qualification to do the job. Just a couple of days back, it came to light that apparently Shraj had been petitioned and had acknowledged receipt of the petition. A copy of the Shraj's response and the petition had also now been submitted to the Parliament, and is going to form a basis for the scrutiny. And this is a petition that is anchored on a suspicion or an assertion that the nominee has breached constitutional provisions as it relates to the Declaration of Assets, Article 286 of the Constitution. And it states that the nominee has been a justice of the Court of Appeal since 2008 and was required under the Constitution of Ghana, which is the highest law of the land, to have declared his assets and liabilities. The petitioner asserts that they have evidence to suggest that he has failed to comply with this constitutional obligation, and therefore issues about his qualification naturally arises. And so it's going to form a basis for this. Martin, let me come to you on this. Have you appeared before him before, Enyeba?
Oh, several times.
Okay.
Yes, several times. Yeah. So what are my thoughts? So you say
good nominee for the job.
So yeah, good man, definitely. That one, he's been on the Supreme Court since 2008, and he's discharged himself admirably. Excellent. Okay. So as for the job, yes, he can do it because having been on the Supreme Court for these years, he's closely. Even if you like, even if you say remotely, whichever way, he's seen how CJs have carried out their functions. So he's learned a lot, and so I don't think it will be too much of a big challenge for him to run the judiciary.
So every lawyer I've spoken to, and I've spoken to a lot of lawyers, very senior lawyers, everybody agree, qualification-wise, is good.
Yes.
So why is there this heated controversy around him? I mean, I know the issues about the time, when to do it, give the time. What's your reading to how this is played out in the public domain?
Okay. Well, the reading fortuitously is also out there in the public domain because, especially from the minority, they've made a case of regional balance, okay, in their appointment. So I think right now, if you look at the first four officers of the country in terms of hierarchy, from the president to the Chief Justice, they've come from certain major ethnic groups. And the Evers are quite a major ethnic group. So based upon that, UNICEF Sini was making a point that it would have been better if they gave it to Justice Doche. Yes, he's drawn inspiration from the Constitution and all that. Yes, that's it. That's our democracy. It's good he's made this point, but in matters like this, it's the president who has the last say. But fortunately, I understand Justice Doche has more years to go. So it means that Justice Enyeba will retire before Justice Doche. So hopefully, I mean, the third time around,
there's a controversy about who is senior to who.
Sorry?
There's a controversy about who is senior.
Oh, there is no. Justice Doche is senior. He's senior to Justice Enyeba.
So if that's the case,
yes, but
shouldn't he automatically get a job?
No, as for the word automatic, that's not the one to use.
Because as of today, he's acting.
Yes, he's acting. That's why I said, you see, bottom line is that it's a prerogative of the president. So that one, it becomes a very slippery road to say that at all costs you should give it to the most senior, especially as in the recent past, that's not been the practice. Justice Sakwa wasn't the most senior when he was appointed, Then when it came to C.J. Wood, Justice Pega was senior, but he was bypassed and it was given to Justice Wood. And then Atuguba was senior. Actually, no, as for Justice Atuguba and so far, they came to the Supreme Court on the same day. But I think at the bar, yes, at the bar, no, he even said they were mates from school. So, yes, they were mates from school, right? So that's complex. So at least in the case of C.J. Wood and the case of Aqua, they weren't the most senior. Yeah, they were given. So the seniority thing, that's why fortuitously, at least, the Constitution makes it clear, it's in Article 144, that in the absence of the CJ, the most senior acts. So currently, as we have it, I think Justice Ansah is actually more senior to both of them, but for some reasons, he's not the one acting. I don't want to go into that. So bottom line, the minority have had their say. Yes, there's something to be said for the regional balance, so that if they had given it to an Ever, it would have balanced the equation, because the number one man is an Akan, vice president from the north. Okay, so CJ, then if they had an Ever, since Professor Ukwe is a Ga, you see, so there's everything to be said for that, but well, unfortunately, that's not how it works out in the president's calculus. He's taking his decision. So I think we should all rally behind the president's choice so that Justice Enu will do a good job. It's good. It's good that the minority have had their say, but let the majority have their way. Let's go.
Let's come to what we now know to be the petition, and you're a lawyer as well, so you can help us here. This petition bordering on violation of Article 286 of the 1992 Constitution that has been filed against him. Charge is investigating, but it's already gone to Parliament as well as part of the memorandum they're going to do. Is there enough basis there, if it's proving, to pose a challenge to his confirmation?
I think ultimately it will depend on whatever reports that may be submitted to Parliament by Raj. Because it is the duty of Parliament to do what they are going to do. So all other, material that is important, whether it's a petition, whether it's evidence or whatever, will have to end up there. The charge on its own cannot, technically speaking, prevent him from being the CJ. But of course, these are fundamental issues that have been raised. As of now, no evidence has been provided. We don't know what the true situation is. So I think we should just wait for the processes to pan out properly. And at the end of the day, whatever the reasons for the petition, the findings and what have you, when they are all submitted to Parliament, together with all the bits that they may gather as well, because we also don't know what others may present. Yes, we know of this petition, but people are also allowed to present whatever they think to Parliament. For now, it's the petition that we know about. So I think it's a composite thing. It will be difficult to just say that this petition alone is good enough to stop him from becoming the CJ.
The asset declaration law, if it's violated and it's proven that it's violated, I mean, even beyond the CJ nominee, is it penalty there that could disqualify one from holding public office subsequently? What does the Constitution say? What is the penalty for violating the asset declaration law?
Can I have Article 286?
286. 286. I mean, and thankfully the petitioners quoted extensively from it. It says failure to declare or knowingly making false declaration.
Yeah.
This is 286(2). Failure to declare or knowingly make false declaration shall be a contravention of this Constitution and shall be dealt with in accordance with Article 287 of this Constitution. So educate us on what this means, if indeed it is a violation.
Yeah, so 287 has it that an allegation that a public officer has contravened or has not complied with a provision of this chapter shall be made to Shraj. And in the case of the Commissioner for Shraj, to the Chief Justice, who shall, unless the person concerned makes a written admission of the contravention or non-compliance, cause the matter to be investigated. The Commissioner for Shraj or the Chief Justice, as the case may be, may take such action as he considers appropriate in respect of the results of the investigation or the admission. So you see that.
Just a question. So basically, this is what I was saying, that it will depend on what they submit to Parliament.
What Strad will submit?
Yes, the report. That's what the Constitution says, that it is the outcome of whatever Strad will do is basically what will be sent to Parliament. And as of this point, you know, if you look at some of the rulings from Strad, there have been instances where they could have said that, well, maybe, for example, there was some procedural error or certain things may have happened, but it is still not enough for this.
Yeah.
You know, so at this point, you cannot just say that because there's a petition, automatically it bars him, in quotes, from becoming a CJ. And we cannot also preempt exactly what Shraj will conclude on and the sort of report that will be sent to Parliament. It will be on the strength of that and what Parliament also thinks, based on other considerations, that we can come to such a situation. But as far as the system is concerned, it is a process that is important. His qualification, I don't think anybody doubts it. Both sides of the divide agree that the man is competent enough to do the job. I heard Musa Husseini himself say what he said, but at the end of the day, he still congratulated him that on principles of law, he's solid. And there's this argument that, oh, a certain balance and what have you. And like Martin said, that for now is the prerogative of the government, sorry, the president. And the president has triggered the various processes that are important. Some are also arguing that, look, maybe for this whole exercise, we should take our time and build a certain consensus. But truth be told, look, the last time that we unfortunately lost our president, because there are clear-cut constitutional provisions, the vice president clearly, within 24 hours, was sworn in to be the president. We could have said that he should still be the acting president, so as we build consensus. No. This appointment goes to the highest level of the judiciary. So he is at the top. And I think that this practice of wanting people to be in acting positions for years, we should discourage that. If, for example, we look at, say, Justice Akwe's case, where he passed on because of ill health, this is something that you could not predict. For which reason, you couldn't say that a certain process should start. So in that space, if there is somebody in an acting position for a longer period whilst the president tries to sort out who ultimately should be nominated and what have you, that would be fair. But in situations like this, where we know clearly that the current, or let's say the outgone CJ was going to retire on this particular day, I think it is also prudent that the president begins the necessary steps so that we don't have these acting positions for long. So for me, I think the president has done the right thing. Parliament likely has also come to a consensus on the date. So the process should continue for us to have an appointment ASAP.
Martin, what's your interpretation of the article you read from the Constitution and how it may apply in this case?
Yeah, so I basically agree with Justice. You see, the bottom line is that 287 says that the Shraj may take a decision as they consider appropriate. Okay, so meaning that then they may say, oh, we look at this, maybe we don't think this is enough to bar him from ascending to the office of CJ, or they may say, okay, and most, I think that should be the way, let him declare the assets and then let the process continue. Because definitely, in going into the office, this will be done. Assuming, you know, right now, that's the danger we are facing. We don't know if the allegations are true. So in actual fact, we should have started from that point. Yeah. You see, so if it turns out to be true, the way I see it is that they would say, oh, let the assets be declared and then go on. Because especially in the context of the fact that, you know, this is a law that has been breached more than has been observed. Yes. So if you were to go strictly, then so many public officers will have to back. Exactly. And even if you look, there is a book. In the US, they also have such a challenge. You know, Clarence Thomas. There is this book that I read. case against the U.S. Supreme Court. Okay, in it, the lawyer, Erwin Cheminsky, makes a case that Clarence Thomas in office now also had issues with declaration, work that his wife did. The declaration wasn't filed, but the man is in office. So it's not only in Ghana here. Yeah, you can check out the book. I have a copy. If I had known this, they said I probably should have brought that. It's in there. The case against the U.S. Supreme Court, okay, written by Erwin Cheminsky. He's an eminent U.S. constitutional lawyer. So he's referred to instances where the eminent judge on the U.S. Supreme Court doesn't have his declarations filed properly. Well, he's in office.
Can anybody on the committee, appointments committee, make a case that because this is before Shraj, and Shraj is investigating, Shraj hasn't concluded yet, we should hold off confirmation until we get a report from Shraj?
Certainly, it's a reasonable argument to make. But if you come again to the context that so many public officers, and also even the regime, you know what? You know, Occupy Ghana has had issues with it, and they are battling the Attorney General. The regime is very weak. I mean, the asset declaration regime. You fill the forms, put them in an envelope, seal, and then give the Auditor General. So until there is trouble, nobody knows what is inside. If you read the law, it continues. It says that it will only be opened when a court of law asks for, or a commission of inquiry, etc. So really, our regime is very weak. So it's good that maybe Occupy Ghana, perhaps this one will also serve as an impetus for them to continue to ask for further reform so that they'll make the law more biting. But for now, I really am struggling to see what purpose will be served to say the vetting shouldn't come on Monday, especially as it's a form that's merely filled and put away. Yeah. And put away. So if you had said that, oh, there's a commission of inquiry right now sitting that's asking for the justices, CJ nominees, asset declaration forms and all that, then would have said, oh, a constitutional issue has arisen, or if there were a court case. But as we speak now, there's no court case against him and all that, so the risk is very minimal. Yes.
There's also, before I come to Kweku, there's also a big conversation around building consensus around his vetting and confirmation. Justice Yankson has talked about this. There's a sense that already, from the debate that has ensued until getting the date fixed, that the minority-majority side are sort of divided on the matter. There are those who believe that, you know, he's not the right person. We've articulated that already. Is it important for both sides to build consensus around it so that it doesn't become a majority alone approval, if that comes to it, for a Chief Justice?
Oh, yes. You know, as a people, because we are communal in nature, every time these high-profile appointments come out, yes, we are always asking for consensus. But it also appears that a lot of the time, the governments don't listen, not much. You remember, but at least the last time the president did it well was the appointment of Martin Amidu. At least he took somebody from the opposition, right? But I remember the most contentious was the EC's appointment, Mrs. Jean Mensah's appointment. It was very acrimonious, but there was no consensus. Look, we've always been this. You know, you meet two Ghanaians, and when there's a discussion, you find out there are three opinions, though you see two people. So what I'm saying is that, yes, consensus building is good for our democracy, but there comes a time when, well, the president, because we don't have much time, it looks like, well, okay, you've had your say, but let the process also go on. So you see that in the consensus, you know, initially they said the minority said they were not going to participate.
In fact, they were going to boycott the process.
Excellent. But eventually, you know, they went, they talked, so they came to a consensus that let the vetting go on Monday. So for me, it means that to the extent that they've subsequently met and have agreed that they will do the vetting on Monday, and I thought I heard Haruna say that they will participate, I mean, actively, right? So I think that in itself is some consensus building, you say. Yes.
But Martin, just to add a bit, you see, this consensus building, I think we should also look at it in a particular context. If we are saying this relative to Parliament, that is fine, because they are masters of their own rules. Yes. But if we extend it to the bigger picture, then we may even be asking for a referendum and what have you, because as a CJ, whatever he does, for us as, say, lawyers, it will impact us. For the ordinary man who has to seek justice, he will also be impacted, not just political parties. Political parties may represent some views, but there are some people who don't even subscribe to political parties.
Excellent. And we are so many.
Yes.
We are so many.
So for me, the key thing is that the procedures as established in law should not be flouted.
Yeah. Yeah.
The bits about consensus should not be played out such that it will derail the processes.
Okay. So, Evan, let me make this point. Actually, from Samson, the regular host, it says somehow I think the impression was created that upon the demise of President Mills, there had to be consensus building as to who would take over. But he says that from the way he sees it, the Constitution is clear that it's the Vice President who takes over. You say,
okay, so let me correct. Well, I just cited an example that, look, when President Mills passed on, there was nothing like consensus building because the procedures were established. The law was clear, black and white. So in this case, we have a procedure that says that, look, these are the steps that ought to be taken for the CJ to be confirmed or otherwise. So we should let the processes go on, just like it happened with one arm of government. Basically, that's what I was trying to say.
Okay, let me bring in quickly, but just before I do that, I just want to remind you that NewsFile is brought to you by MTN. Everywhere you go, Star Assurance, your solid partner. Bank of Africa, strong as a group, as close as a partner. Istiqbal, quality beyond measure. Amen Scientific, God is the healer. And the GIA, always remember, insurance companies, claims payment, our business. And don't forget, be live on your most authoritative news analysis and current affairs NewsFile this coming Saturday, December 28th. For the end of year broadcast is myself and Samson Ladayenini, who will be back next week, by the way. He's away for the show. We'll take your views and questions as we host a panel of experts and distinguished guests to review major issues and developments that made headlines this year. Come, let's review matters on corruption, education, economy, health, elections, vigilantism, and media freedom. Be part of the NewsFile on Saturday, December 28th. Come to the East Wing of the UPSA Auditorium at 9 a.m. NewsFile, your most authoritative news platform. Kuku. So what do you make of all this noise surrounding the CJ nominee?
Well, I'm not surprised. It's not the first time that we've had controversies and problems relative to appointments of Chief Justice. It's not new. Look, but I wanted some clarity from legal minds here in terms of the seniority thing. Because is Dose senior to Eni Yabwa?
Yes.
Because of date of enrollment?
That's the place that to be candid. I've heard two versions. I'm not sure which is true.
No, date of enrollment, Dose obviously is ahead. Yes. He enrolled 17th November 1978. Eni Yabwa is 20th November 1981, so 3 years.
Yes.
But they were appointed but they were appointed the same day to the High Court, Court of Appeal, and Supreme Court. Yes. That's what I'm asking. Whether is it the date of enrollment that makes it senior?
There are two things. At the bar.
Yes, that's what I mean.
At the bar is the date of enrollment.
But not the bench.
The bench is the date of the appointment.
Yes, and they are the same.
At the bar,
on the bench, they are the same. That's the point I want to
make. But the seniority is at the bar. So let's say I'm senior to Dr. Yansin here because I was called at least maybe 2 or 3 years ahead of him. Okay. So that is it's at the bar.
But in making the decision, is it what should be considered?
No,
I mean, the seniority at the bar or call.
No,
when,
you see,
when,
at the level of the CJ, we are limited to the Supreme Court.
The Supreme Court.
We are talking about the bench, not necessarily the bar at this point.
They all went.
When they say the seniority, most lawyers are referring to the
So
bar.
when people make the argument that John Duche is senior to him,
yes,
they're referring to when they were called to the bar.
Excellent.
Okay. Yes.
No, if that is the argument, then there's no problem. Yes. If it is just about the bar.
Yes.
But the bit about the bench is that they were called, basically same day.
The same day.
They are using the bar. And there's no dispute.
And Godfrey Daming, Deputy Attorney General, also makes a point here. This is the third one. He says that that so far I mean, it says the most senior on the bench after so far is not Duce. The records must reflect. It said it is Ansa.
Yes, that's what he said.
I mentioned it,
Okay.
but for some reasons we need not go into. He's not acting, so it's Justice Duce who is acting.
But the public, I'm interested in knowing if he's the most senior, why he's not.
It looks like, I don't know, it looks like Justice Ansa is not well.
Okay.
That perhaps.
Okay.
Yeah.
Thank you
but
for that.
we have, seniority has never really been the factor
No,
in
no, no, no.
appointing CJs.
It is just the
That's
acting
what we-
bit.
Throughout our history. Yes.
It is just the acting bit.
Yes.
So
Yes,
let's
so
say
the
the CJ is out for whatever period, and somebody has to, in quote, be in charge.
Because you said acting, I've just remembered the battle between Pega and Atuguba.
That one was bloody.
See, let me show you this thing. This is a letter dated 26th March 2007. Okay? It says official statement on death of the Chief Justice of Ghana. And I read, as is known, the Lord Chief Justice George Kingsley Acquah unfortunately passed away on the 25th of March 2007. In the circumstances and as provided under Article 1446 of the 1992 Constitution of Ghana, the most senior justice of the Supreme Court performs the functions of the Chief Justice until the vacancy is filled. Accordingly, in view of the fact that the most senior Supreme Court judge, Mr. Justice Francis Y. Pega, is indisposed, all writs of summons should be sealed and tested in the name of Justice W.A. Atuguba as acting Chief Justice. There should therefore be no disruption of the business and affairs of the courts. This signed here is Regina Aputi, Judicial Secretary. Apparently, this letter was drafted by Atuguba. This is the handwritten one, and sent to the lady to type. And there was a huge fight.
Yes.
6 days later, the president appointed Pega as the acting. And so you listen to Pega. Pega says, I wish to acknowledge receipt of your letter copied to me, appointing me as the acting Chief Justice. I'm sincerely grateful for the honor done me to serve my country in this capacity. Your Excellency, be assured of my services as required by the Constitution of our dear country. I shall be available at your convenience to call upon you as and when the need arises. May I take this opportunity to congratulate you on your appointments as the Chairman of the African Union and the successful celebration of Ghana's 50th anniversary. Please accept my kind regards. So he chalked out Atuguba. This is dated 2nd April 2007. It superseded the 27th March 1. But if you know the background, the fight that went on over acting Chief Justice position. See, this thing about petitions and court cases, Georgina Wood, we tend to forget, when she was being vetted, somebody put out a petition in the media, a petition, didn't send it to Parliament. Parliament, if you look at the Hansard, Parliament decided, though that the petition had not been sent to them formally, Parliament decided to question her on the petition. It was about a land dispute that involved her father that had been protracted for many years. She dealt with it. Justice Redu, when he was appointed and was being vetted, there was a case in court. Somebody has sent a case in court against Justice Redu. Parliament decided that, look, we won't touch it because it's in court, but we'll proceed.
They are master of their own rules.
That's right, with the vetting. So they went ahead, did not deal with the court matter because they thought it would be unfair or prejudicial, but they dealt with
what was before them.
What was before them. And he sailed through. So for me, I can see a situation where Parliament will ignore what is happening in Ashraj.
Definitely.
And proceed to vet
and approve.
Now, subsequent to that, assuming Shraj comes out with an adverse findings, we all know what the consequences would be. So for me, I don't think there is much of the problem. The minority stand at one stage, I was a bit worried, but because they've resolved, and forge the consensus to vet, I think sometimes it's better we bury some of those things in order not to create.
Now, what were your concerns then?
No, when I heard the general secretary of the party, not the MPs, so,
Yeah.
because the MPs, if you check the Hansard, you see why there was a little tussle. You know? But I heard Mr. Sidun Ketia make the point that they needed more time to assess, get information.
Yes.
Well, Mr. Ninyabua, Justice Ninyabua, I'm sure he's been vetted by Parliament before.
Yes. In 2008 when he was.
Yes. So how much more time did they need? Some new discovery? Was there any new discovery?
And of course,
They say
I mean, even
Or is this petition?
even us as include political observers or legal watchers, we all knew the leading candidates. So if you wanted to do something, even before the president, came out with his name, you could have still done some work on the leading candidate.
Yes. So, see, I thought that was a bit of seeking to protract the process. Yeah. But thankfully, they've solved it.
But isn't there an unspoken suspicion there? And Inusa Fusini almost said this on PM Express on my show, that there's a view from the minority side that they perceive him in a certain political lens, which is really what the fight is. Nobody will say it publicly, but
see, the Supreme Court petition, the election petition.
They have.
The election petition issues came up.
Yes.
Remember, Mr. Chikata had some problems.
Exactly.
And then Mr. Chikata's own cases that ran through the court. There were some cases that went to the Superior Court for some, deliberations and things. And it appears his position was not favorable to
that of the NDC.
Well, Mr. Chikata. The NDC were not a party. No, so these things happen. Look, Justice Aban, have we forgotten? Indeed, Justice Aban had a double agony in this case, because in 1980 or 81, Parliament rejected him. May he rest in peace. So I won't recount what the Parliament meant by lack of moral integrity.
Even the Bar Association was against us.
No, that is the subsequent one.
Yeah.
So he lost. Parliament voted against Aban. But before they could deal with Apalu, Chief Justice Apalu, I think there was a walkout. And that went to court.
Tufo, yes. The Supreme Court said Apalu continued in office.
Continue. Yeah. No, but Justice Aban, fast forward to 1995, because of the page 28 saga, the Bar Association protested and actually went to court.
Yes.
But lost.
They lost.
So it's not an unusual development that Chief Justices nominees are put forward and then there's some little controversy, some being political and things. I don't think it's a big deal. This Chief Justice will sail through the vetting. I see it happening, especially when both sides say he's eligible, he's overqualified. So he will sail through. Yeah. What happens at Sraj will be another issue.
And a quick comment on this question. Is it true, because there's a lot of suspicion about Chief Justice's controversial suspicion of political, favoritism, and so that people take one interest. But if you look at the practice and the reality, when they go to the bench, has it proven that those suspicions are legitimate? As in, the person gets to the bench and takes decisions that is against a political party. What does the evidence show? Because in politics, it's very easy.
Can you find Raymond Atukuba?
Exactly.
He did that research.
But truly, the one that comes to mind, look, Justice Akins was a Attorney General, Secretary, Justice under the PNDC. Yes. Classic case, the 31st December case that went to court. He wasn't on the side of the PNDC, of the NDC, because then it was NDC. That's a case that comes to mind. There are many judges who even had political roots before they became judges and have been appointed. You have to check their
voting party.
Yes, that's why I say we should look for Raymond.
Because he did that.
He may help us.
Yes, he did that. But just to add to what Amkweku said, you see, this question you raised is not limited to just Ghana. Even in the United States, in the appointment of Supreme Court judges, there is always that bit that, look, if, let's say, Donald Trump is appointing somebody, the chances are is going to be, in quote, somebody who is more pro-Republican.
They don't hide it there. It's philosophical and ideological.
Yes. But you see, for particular issues, these judges also go there with their independent minds and then juggle the legal rules as well. So like we just said, it is not always that the person you appointed will vote, in quotes, when it comes to a decision for you. His decision could be directly opposite what you were looking for.
That's right.
Yes.
Yeah,
and then sometimes, you see, the other bit is that a dissenting view, which everybody may look at and say, oh, this actually plays in favor of one political party, over a couple more years or so, could actually become the true legal position. We've seen those bits. There are dissenting views that subsequently have become the right legal position and have even been legislated upon, not just court or judge-made law. You know, so sometimes these perceptions are there, but ultimately it is the competence of the persons involved.
Now, what your answer to that question? That's it. What does the evidence say for you?
Well, it's mixed. It's mixed, actually, you know. You see, and the example Uncle Kweku gave about Justice Akins. You know, at the June 4th trial, he was prosecutor, right?
Yeah.
Yes.
If you look at the facts, the way he read, I mean, the facts as he assembled, everybody says that actually that helped Rollins.
Yes, because Rollins didn't speak.
Yes.
People don't know that.
Yes.
Rollins didn't speak
Look at the facts. He said this is a man trying to bring about an end to corruption, injustice. That's the prosecutor's fact. You see it. So it's a very complex thing. Of course, as for the perception that when a certain government appoints judges, it would usually be thought that the judges will favor those governments when a decision involving the government comes up. We can't do away with it. It will stick forever. I mean, well,
the perception.
Yes, the perception would. But the reality is far more complex.
Okay.
You see, the reality is far more complex. So, well, let's...
Well, Samson sent one in about Eniyebwa. It says Eniyebwa in the presidential petition was with the majority ruling unanimously to dismiss about 3 heads of the claims by the petitioners. Why align him and tag him where he departed with the majority to hold for the petition?
Interesting point.
Other heads of claims.
Very interesting point.
Yeah.
That one, what they're saying is that when it came to the ultimate, I think that's always been the point. They wanted the whole election thrown out.
Yes, but you see, here he was, there were the Jebel issues that he had to deal with. So if he felt that some were unmeritorious, of course, he had the right to say it, because that is what we expect judges to do. We don't expect them to rubber stamp.
Yeah. Kweku has now sent one in. He says appointments to the Supreme Court have nothing to do with seniority. The president could have appointed any qualified person, including persons who are not currently on the Supreme Court or even the bench. However, Parliament must have a reasonable time to vet all nominees to the Supreme Court. 1 week is not reasonable, even for a nominee who is on the Supreme Court and is therefore prima facie qualified. We must approach this exercise with some seriousness to avoid worsening the perception that Parliament merely rubber stamps nominations. A few of the views there.
There's a point there. Look, Justice Archer, he was brought back from retirement, late 80s, and made Chief Justice. He had retired.
Yes.
And brought back, but
from the bench.
Yes, and there was also one Bannerman, I think 67, 68. He was in Kenya. He wasn't a part of the senior justices in this country. He was brought and made a Chief Justice.
Yeah, and Justice, and we have a couple of our judges who have also gone out of Ghana to be Chief Justices elsewhere. Yes.
So we're going to take a break. When we return, we'll continue with the theme of Chief Justices and look at Madame Sophia Kufu. Well, when did she formally retire? Overnight, right?
Yesterday, close of day.
Close of day.
Close of day yesterday.
So as of this morning, she is an ordinary citizen, stripped of all the powers, the enormous, tremendous, scary powers of the CJ. I'm sure she probably is resting quite nicely on the couch, possibly watching us right now, you know, enjoying her retirement. And when we return, we'll look at her legacy. Going into, of course, some of the decisions she's reviewed, but the controversial issue also of legal reforms. And then we'll come back to Eniyebwa slightly, because this week when Sophia Kufu was giving her, you know, departing speech, She said, those who think that Eniebo is going to come and, soften the rules, you don't know what you're talking about. The guy, possibly the guy is even more a stickler to the rules than she was. So when we return, we'll look at that and see where we stand with where she left the judiciary. Stay with us.